I think the U.S. regulatory framework is very inefficient. Just for my own personal view, I would still have plenty to do
Written by a lot of different people with
if
different
we had
ideas.
a more rational and unified approach to this. But most of my clients, because I do a lot of work in the financial services and in the healthcare space, and so there's a lot of different regulatory and overlapping jurisdictions there. And so I think there are certain regulators that tend to be more aggressive, but it also varies by state, and it's also informed by different economic trends. So, for example, we have seen, an uptick in oversight and cases brought by the Texas AG, which a lot of people think are tied to the movement from California to Texas of major tech firms and private equity activity, right? So it's not something that you would necessarily think about. Certain AGs also have certain issues that they just care very deeply about. And it, becomes an area of keen focus. And you can see that across, the whole panoply of different regulators. They're also inherently, in some cases, political beasts. The SEC changes with the political administrations, it changes leadership, it has shifting priorities. And so that is something that we expect, of course, at the federal level. We saw, in the first Trump administration, how federal regulation really was pulled back and the states moved in. So the state AGs and the state financial regulators moved in to fill that gap and then never really stepped back during the Biden administration and now have continued that path. So I think, one of the things that it's important to me when I'm counseling a client is to think about what are the regulatory relationships that are really important to you? And what is your strategic plan for growth or expansion? And you need to have an understanding of where those regulatory risks lie. If there are existing examinations, investigations, if there are consent orders, right? There are all these different collateral consequences that can kind of be in the background initially, but actually become very important when you're trying to devise a strategy for managing through an incident and those various different risks. And I think, on balance, the regulators that I have interacted with have all been, almost to a T, incredibly conscientious and not
Mhm.
abusive. They're trying to fulfill their own regulatory mandates, right? Which is to
Sure.
make
Yeah.
sure that these companies are doing what they're supposed to be doing and complying with the regulations. And we see how hard it is for them to do that. If you look at some of the actions that have been brought that center on what is reasonable security. It's actually pretty hard for regulators to say and to prove that something was in fact not reasonable security. Does that mean that the whole thing is in fact not reasonable?
Yeah.
I would happily defend that case,
But where
right?
is
It's
that
much
line?
easier.
Where is that line? Like, where is that line between bad luck and negligence and whatnot? Like, do you see any commonalities there, or is that not really established?
I mean, it depends, right? I think, the general rule of thumb is that you want to flag risks. You want to identify risks and then figure out how you're going to handle them. And sometimes you have to accept the risks in a short term or you put compensating controls in place. Other times you were like, we've got this handled. We have a best in class tool and we feel great about it. But there are tremendous budget constraints and you can't spend all of your money on cybersecurity. It's just not realistic. And so then the process really becomes like what are your risks and how are you managing them and to do that in a way that is reasonable and defensible and that will really set you up for success.